Welcome to Invest Northern Ireland's COVID-19 Response webinar series.
My name is Lindsay Mallon and I'm joined today by my colleague Colin McElroy. I'm the head of the Corporate and Commercial Department here in Arthur Cox, Northern Ireland, and Colin is a partner in our Finance Department with particular focus on restructuring and insolvency. Before we begin the webinar, I would just ask you all to note the disclaimer. The information contained within this presentation is general information only. It's not to be construed as specific legal advice in relation to your particular set of circumstances. If, however, you do require specific legal advice, you should, of course, contact a specialist lawyer. We disclaim and exclude any liability in respect of the contents of the information presented this morning or any action taken based on this information. What we're going to cover in the webinar is COVID-19 and directors' duties under the Companies Act 2006, the upcoming insolvency reforms, COVID-19 and contract management, how you can manage your essential and statutory business activities such as board meetings, and executing legal documents in this period of social distancing. As many of you will or should be aware, the Companies Act 2006 was an attempt to codify the duties imposed on directors by case law and equitable principles. As many businesses find themselves in financial distress as a result of the economic fallout from the coronavirus pandemic, the directors of those companies must pay very careful attention to their duties. In particular, two of those duties deserve specific mention in the context of the current crisis, and that's section 172, which is the duty to promote the success of the company, and section 174, which is the duty to exercise reasonable care, skill and diligence. By way of a very brief recap, the duty under section 172 of the Companies Act to promote the success of the company for the benefit of its members as a whole generally requires a director to have regard to a non-exhaustive list of other matters, which includes the likely consequences of their decisions in the long term, the interests of the company's employees, and the need to foster business relationships with suppliers, customers, and others. Directors need to seek to achieve a balance between the need to ensure the survival and long-term success of the company and the decisions needed in the short term, such as cost reductions, prioritising critical payments over non-critical payments, and protecting their workforce, which may potentially have a short-term impact on the company's financial and trading position. However, when a company is financially distressed and insolvency becomes likely, a director's duty to promote the company's success, i.e. to act in the interest of the members as a whole, is replaced by a duty to act in the interest of the company's creditors as a whole, that is to preserve the value in the company in order to maximise the potential return to creditors. While there is no offence of trading whilst insolvent, directors who do not take every step to mitigate losses to creditors once they conclude or ought to conclude that there is no reasonable prospect of avoiding insolvent liquidation face liability for wrongful trading under the Insolvency Order. It's important to note that directors may be liable for wrongful trading even though their business is not actually trading, but losses are increasing, and that's particularly relevant in the current circumstances surrounding COVID-19. The next duty that I wanted to touch on briefly is section 174 of the Companies Act. And again, just by way of recap, this section imposes both an objective and a subjective test on directors. Therefore, as a director, you will be judged, for want of a better word, in terms of what would reasonably be expected from a director in your position, as well as on the basis of the skill set and the expertise that you actually possess. So to bring this back to the current COVID-19 pandemic, clearly the decisions that you as directors take will inevitably evolve in line with the national situation. We will look at the practical steps that you should take in the next couple of slides, but it should be remembered that just because, for example, your sales director, that doesn't mean your duties only apply in the context of sales and customers, or just because you're the HR director, you only need to worry about employees and HR issues in the current circumstances. Your duties as a statutory director apply regardless, and therefore you can't ignore the financial state of the company just because it doesn't come within your list of day-to-day executive responsibilities. If you do fall foul of those duties, then what are the potential liabilities that you may face as a director? I think before we look at the steps that directors can take to protect themselves in the current circumstances, we should just quickly cover what those potential liabilities are. As my colleague Colin will shortly cover this in greater detail, and the government has announced certain reforms in this area, I will just touch on this very briefly. But in short, if a company is insolvent, the directors are at risk of potential personal liability under Article 176 of the Insolvency Northern Ireland Order 1989, or potentially disqualification under the Company Directors Disqualification Northern Ireland Order 2002. The minimum period of disqualification is 2 years, and the maximum is 15 years, depending on the seriousness of the offence. There are obviously some prudent steps that directors can take in terms of mitigating the effects of the current circumstances. Firstly, board meetings have never been more important. Decisions should be based on up-to-date and robust management information, including daily cash receipts and payment requirements, longer-term cash flow and trading forecasts backed up with appropriate risk analysis. Directors need to carefully record any decisions they make and the reasons for those decisions in case they may come under scrutiny in the future. Discussions with stakeholders will also be essential, particularly with those in the supply chain, and if necessary, directors may need to consider whether alternative suppliers are available. Directors should also check the terms of finance documentation to see whether they are at risk of breaching any financial covenants. Realistic financial forecasting and early conversations with lenders can make a huge difference to the survival of the business, and particularly now when government is working with the banks to help the businesses affected by coronavirus. The same will of course be true with landlords, and business rates holidays may help, but rental payments will also matter and be very important going forward. You should also check contracts for the effect of force majeure clauses, which I will come on to a bit later in this webinar. You should also check the terms of any relevant insurance policies to see if cover is available. You might also have illegality provisions in your contracts, which would be relevant where government advice or action has required your business to close. And most importantly, directors should seek professional advice from the appropriate specialists. I'll now hand over to Colin, who will take us through the proposed insolvency reforms in this area.